It's never happened before that a draft opinion from the court has leaked like this. Typically, when the court has overturned its prior cases, it has done so to correct an earlier failure to recognize or protect rights. And what this draft opinion does, which is to say, those rights we previously recognized, we're taking them back. That's not something the court has ever done before.
We are not going back!
Not ever!
Not ever!
Not ever!
Not ever!
Hi, I'm Kate Shaw. I'm a contributor at ABC News and a constitutional law professor at Cardozo Law School. And I'm going to break down what we know, what just happened over the last 24 hours with the Supreme Court's unprecedented leak of the draft opinion in the Dobbs, Mississippi abortion case. There's just never been a draft opinion that has seen the light of day while the process of refining that opinion was still underway. So the way it typically works is the court hears arguments in a case, someone is assigned the ability to draft the majority opinion. They send around a first draft, and sometimes a very protracted process of negotiation and compromise follows, and the opinion changes a lot. And only when all of that is done, only then do the opinions get released. So it's really hard to read the significance of some of the details in this opinion. But I think it's hard to miss the bottom line significance, which is that unless something pretty dramatic changes inside the court is going to overturn Roe versus Wade, Planned Parenthood versus Casey, and allow states to restrict or totally prohibit abortion if they choose to. And that has not been the case since 1973.
The Supreme Court today ruled that abortion is completely a private matter to be decided by mother and doctor in the first 3 months of pregnancy.
The draft says the words Roe versus Wade hereby is overturned. So there's no question that the court has the power to overturn one of its precedents. It has done it many times in the past. I hasten to add, it has never done it in a case like this, where the overturning of a precedent entails rolling back rights, right? Removing rights that have previously been recognized and extended. Typically, when the court has overturned its prior cases, it has done so to correct an earlier failure to recognize or protect rights. And what this draft opinion does, which is to say, those rights we previously recognized, we're taking them back. That's not something the court has ever done before. This is an enormous change in terms of the ability of women in this country to genuinely enjoy kind of free and equal citizenship stature, which the court had recognized and appears to be on the precipice of formally repudiating, has recognized that the ability to control if and when you become a parent is critical to your full participation in the political and economic and social life of the nation. So I think that its significance, right, for women, for all Americans, absolutely cannot be overstated. A lot of the language and the logic of this opinion suggests that other Supreme Court rulings are quite vulnerable to being revisited and potentially overturned by this Supreme Court that appears really emboldened to, torch longstanding precedent because there are the votes to do it. And so you could see cases like Griswold, which protects the right to contraception, Loving versus Virginia, which protects the right to marry someone of a different race, Obergefell versus Hodges, which protects the right to marry someone of the same sex. All of those cases use reasoning similar to the reasoning that Justice Alito suggests was wholly illegitimate in Roe and Casey. And so I think all those cases could potentially be on the chopping block. And I mean, if the court actually really does revisit one or more of those cases, I think that would be an incredibly, seismic development. And I think it does suggest that whatever, fealty to precedent and stare decisis some of the new justices on the court pledged when they were in front of the Senate Judiciary Committee for their confirmation hearings, either none of that was sincere or in good faith. And this is a court determined to do kind of maximalist change on the court simply because there are the votes to do it and to fundamentally reshape our law. And I think there is a question of whether the American public will be comfortable with a court that exercises that kind of power and that does it in a way that is so inconsistent with public opinion. 2/3 of Americans in every poll report that they don't want to see Roe overturned today. So I think that the court could very soon be in a legitimacy crisis point. This opinion seems to me very much one enormous step down that path.